Hello, everybody. We're starting week 4, and week 4 for you is going to be a pretty busy week. So I'm going to keep this recording as short as I can make it. I don't want to go on too long. And my written announcement is also not quite as long as they usually are. I don't want to take up a lot of your time repeating information that you're going to have to read in your textbook and in the readings that go along with this week's work. You've got 3 main tasks this week. One is our discussion board, in which I have assigned you roles. You read the written announcement for week 4. And in that written announcement, you will find the role that you've been assigned. I've done it alphabetically. So just look at the look at the beginning letter of your last name, and you'll see which position you've been assigned to take. The second task you have this week is to write a blog about the insanity defense. And I'm going to talk to you about that just a little bit in a second. The insanity defense, not so much the blog. And your third assignment is to create, this is to me this would be difficult. I'm not a very creative person, but this is, your assignment is to create either a podcast or an audio recording or a script, a written script, asking yourself and answering the question of, does the punishment fit the crime? And in that, what you need to do is to examine the kinds of punishment that we use in the United States in our court system. I don't mean parental discipline. I'm talking about the kinds of punishment that courts use. I'll talk about that again in just a moment. And after you explain the forms of punishment that are available through our courts, then you need to provide some ethical context in which those punishments are meted out. What is the ethical justification, for instance, for imposing the death penalty on someone? What is the ethical justification for imposing, and this is very controversial at the moment, mandatory minimum sentences on, let's say, nonviolent drug offenders? At any rate, you'll get into that yourself in your own podcast. Keep your podcast or your audio recording or your script tight and focused. Don't go on at too much length. And I know that I'm not one to talk because sometimes these recordings get to be a little bit longer than they should be. But don't do as I do as I say. Okay, let me go back and just talk a little bit about the discussion board. Your discussion board topic this week is one that you may not be very familiar with, and it's about civil commitment as a tool to prevent future crime. Now that right there flies in the face of some fundamental legal principles on which our whole system is based. We do not punish people for something they haven't yet done. You have to do the crime before you can be punished for it. Or, well, there are a couple of steps in between there. You have to be charged and tried and found guilty and then punished for it. But you have to have done it first. We don't look at a person and say, you know what, you look like you might be a criminal someday. So in order to prevent that, we're just going to lock you up right now. We don't do that. But do we? There is a mechanism available in most states called civil commitment. And it is civil. It's a civil procedure. It's not a criminal one. And it is used, most of the time actually, it's used to put people who are in danger of hurting themselves or others as a result of alcoholism or drug addiction, usually. Put them in, and sometimes insanity, and put them into a mental institution for a statutorily imposed period of time in order to allow them to come out of their dangerous period, the period of danger to themselves, the period of danger to others. It is not, civil commitment is not primarily a technique used to nip crime in the bud, so to speak. But sometimes it is, and here's how. Let's say that we have someone who has exhibited dangerous criminal tendencies in the past, who has, for instance, been tried and found guilty of sexual assault. The person has served his or her time, is now on a list of registered sex offenders, which is usually what happens in every state after the release of someone who's been convicted of a sex-related crime. But now that person is out on the street and is, according to neighbors and friends and people in the community, exhibiting signs of getting ready to commit more crimes. Now, that's a pretty nebulous statement to make, and I meant it to be, because what else can it be? I mean, if he or she, usually this is a man, but if he or she is exhibiting unmistakable signs of getting ready to commit a crime, usually the crime's being committed. But there are nebulous signs like hanging around schoolyards when you're not supposed to, or following young women in the dark in the streets, or unwarranted touching or approaches. All kinds of things could be taken as a sign that the person is about to relapse into a former pattern of criminal behavior. And some states allow people who are exhibiting these tendencies, especially if they're coupled with other psychiatric, let's say, hallmarks of one kind or another, to be committed to a mental institution for a period of observation and evaluation. That's called a civil commitment, and the procedure will vary from one state to another, but it usually involves having a judge or a special justice appointed to, who is a lawyer always, who is appointed to hear the case as a neutral arbiter. And then the party who wishes the person to be committed, usually a family member, sometimes a probation officer, sometimes another public official of some kind, but usually family members, will bring the case for commitment in front of the judge. And if the person who is being subjected to this procedure wishes, he or she can bring counsel of his or her own and defend on the basis of the lack of necessity for the commitment. If the person is committed as a result of this procedure, what that means is that he or she will be transferred, usually by a sheriff's deputy, to a mental institution, usually a state mental institution. It could be a private one, depends on the arrangements that the particular locality has made. But at any rate, it will be a mental health facility. And at that point, the the person will be evaluated by appropriate medical personnel, psychiatrists, psychologists, neurologists, whoever might be appropriate under the circumstances. That will vary from place to place and from case to case. The process of civil commitment is not controversial, really, when it's used for its most common use, which is to get alcoholics and drug addicts back on the path of being dry or sober. It's a way that the state essentially picks up the tab for that. However, it is controversial when it's used to lock up, and it is a secure facility, lock up a person who hasn't yet committed a crime. It flies in the face, as I said at the beginning, of our fundamental principles of criminal justice in this country, which is that we do not use prior restraint. Prior restraint is a trigger phrase, and it is an unconstitutional action. It means punishing somebody for something they haven't yet done, or keeping somebody, restraining somebody from performing an act that they have not performed, but that you just think they're going to. We don't do that as a rule. We certainly don't do it in the criminal justice system, which is why this procedure, this commitment procedure is a civil one and not a criminal one. Is that a way of skirting around the criminal prohibitions? It might be. And that's what you need to discuss in your discussion board. Half of you, there are 26 people in this class. I've assigned the first 13 of you alphabetically to argue the position in favor of the use of civil commitment, and the last 13 alphabetically to argue against the use of the civil commitment procedure to prevent criminal behavior. Please read the assigned readings in your learning module, and do any other research that you think is helpful. Your textbook has some information about this. Your blog this week, you have 3 assignments this week. You have a discussion board, a blog, and then a little project. Your blog is about the insanity defense, and I just want to talk about that a minute. I don't want to go on at length. I'm already at 11 and a half minutes, and I'm sorry about that. The insanity defense is one of the affirmative defenses in the criminal justice system. Insanity is not a medical term. It's a legal term. And it usually means some variation of the inability to distinguish right from wrong, or the inability to distinguish fantasy from reality, or the inability to control an impulse. An uncontrollable impulse is another kind of insanity. If you like, you don't have to do this, but as an assist in your blog, you might want to find how your state defines insanity. That's not as easy as it seems, because a lot of states kind of circumvent a real definition, and instead of locking themselves into a written definition of the term insanity, what they do is talk around it, and their laws will mention the word insane or the word insanity, but they'll do it in a context that provides an idea of what insanity is without actually formulating a hard and fast definition. But what you need to do is talk about the use of the insanity defense as a defense to a crime. Here's the catch with using the insanity defense. It's a last-ditch effort most of the time, unless you've got somebody who really is a diagnosed psychotic, some diagnosed schizophrenic, some other kind of recognized psychiatric diagnosis that may or may not, they don't always do this, but that may or may not produce criminal behavior or violent behavior. If you don't have that, if you've got somebody who's never been diagnosed with any kind of psychological impairment, mental impairment, psychiatric disorder, and you're raising, and by the you, I mean the defense attorney, is raising the defense of insanity, what you're essentially saying to the court is, my client did this, because you have to admit having done the act, but he or she didn't know what they were doing at the time. That's the essence of the insanity defense. Not, I didn't do this. That's another kind of defense altogether. But yes, I did. I committed this criminal act, but at the moment I committed it, I didn't realize it was wrong, or I couldn't tell the difference between reality and fantasy. I thought I was in a dream or a hallucination. Or I was in the grip of an uncontrollable impulse. That you can understand quite well, I'm sure if you give it a moment's thought, how dangerous that kind of defense is, because in order to bring that defense forward, you have to admit that your client did the crime, committed the crime. Not something you really want to do if you don't have to. So that's the essence of the insanity defense. Your task in your blog is to discuss, is to find an article in which deals with the insanity defense and its use in a criminal case, and discuss whether its use in that particular case was ethical under the rules of ethics that we've dealt with so far. Now I'm at 15 minutes and I'm really sorry. So I'm just going to say very quickly about your third assignment, which is to create a podcast, an audio recording, or a script, as I've already mentioned, based on the premise, does the punishment fit the crime? I'm going to leave that to your imagination. Honestly, I don't know what to tell you to do. If you want to create a podcast, great. I'm happy to listen to it, watch it, however you do it. If you want to do a recording, fine. If you're more comfortable just writing something, also fine. A script that answers the question, does the punishment fit the crime? And by that, it's not punishment in general, fitting crime in general. It is, do the punishments that we use in this country usually fit the crimes to which they are applied? Are they appropriate? This is not asking you to go back to the biblical construct of an eye for an eye. That's not what this means. Although you might bring that into your discussion. It's, interesting. But what it means is, are the punishments that are provided by our current criminal justice system usually appropriate to the crimes to which they are applied? All right, now I'm at 16 and a half minutes. I'm going to be quiet. Please, this is a difficult week. Send me an email asking me questions if you have any. Put it on the general discussion board. However you might need to ask questions, I'm at your service. Have a good week. Bye.